Welcome back to the deep dive. We're continuing our series digging into the MPEP, the Manual of Patent Examining Procedure.
Yep, trying to make patent law a little less intimidating.
Whether you're gearing up for the patent bar, maybe you're a law student, or just need to get a handle on these rules for practice.
Exactly. We're pulling out the key stuff, trying to make it more accessible.
So today we're jumping into Chapter 2100, Patentability, and specifically MPEP Section 2127. That's Domestic and Foreign Patent Applications as Prior Art.
Right. Prior art. It sounds technical, but it's really fundamental.
Okay, so what's the big question this section helps us answer? What's the core issue here?
Well, basically, it tells us when information from older patent applications filed here in the U.S. or overseas can be used to argue that a newer invention isn't really new, or maybe that it's obvious.
Okay, so what counts against you when you're trying to get a patent?
Precisely. It clarifies the rules under U.S. law, 35 U.S.C. 102A1, 102A2, and also the older pre-AIA 102E. It's about what existed before your invention.
Got it. Defining that baseline. So let's start with abandoned U.S. applications. My first thought is, well, if it's abandoned, it shouldn't count, right?
That seems logical, but there's a twist. An abandoned U.S. application can be prior art, but only if its contents became publicly disclosed somehow.
Publicly disclosed. Even though it was abandoned, how would that happen?
The classic example the MPEP gives is if, say, a published patent or maybe another published application specifically refers back to that abandoned application and incorporates its material.
Okay, so it got pulled into the public view indirectly.
Exactly. Imagine you filed a provisional, then a non-provisional, but you let the provisional go abandoned.
Right.
But in your non-provisional application, which does get published, you specifically say material X is incorporated by reference from abandoned application Y.
Okay.
Then that specific material, material X from the abandoned one, can be used as prior art under 102A2 because you essentially published it via that incorporation.
So that act of incorporating by reference is key. What if you don't do that? If the content just stays in the abandoned file?
Then generally it's not prior art. That's the point highlighted by the Lund case mentioned in the manual. If the information wasn't carried forward, wasn't made public in some way, it can't be used against someone else later.
Makes sense. If the public couldn't see it, it shouldn't block a later invention. Public access seems to be the guiding principle.
That's a great way to put it. Public accessibility is crucial.
Okay, so what about U.S. applications that do go all the way and become issued patents? Sometimes things get removed or canceled during prosecution, right? Before publication.
Yes, that happens all the time.
Can that canceled stuff ever pop back up as prior art?
Usually no. If material was canceled from a U.S. application before it got published, it typically can't be used as prior art under 102A or the old 102E. Same logic. It wasn't published.
Typically. Implies there's an exception.
Well, yes. The MPEP points out that if that canceled material becomes publicly accessible anyway, like through the application's file history, which people can often inspect at the USPTO.
The file wrapper.
Right. If someone can dig into the file history and see what was taken out, then it's arguably publicly accessible, even though it wasn't in the final printed patent. So it could potentially be prior art in that situation.
Interesting. So even the process details can matter if they become public. Okay, let's shift gears. Foreign applications that issue as patents, what about stuff canceled from those before they were granted abroad? Same rules.
Actually, no. It's a bit different under U.S. law, particularly thinking about pre-AIA 102B. Material canceled from a foreign application before it issued can still be prior art here.
Even if it wasn't in the final foreign patent, why the difference?
The key factor is whether that foreign application file, including the parts that were later canceled, was publicly accessible in that foreign country more than 1 year before the U.S. effective filing date.
Okay, so it's about the accessibility there and the timing.
Exactly. The Bruckelmeyer case is the perfect example here. Figures were canceled from a Canadian application.
Yeah.
But the entire Canadian file, including those canceled figures, was open for public inspection in Canada within a year before the related U.S. filing.
And the U.S. court said?
Said those canceled but publicly accessible Canadian figures were prior art under pre-AIA 102B.
Yeah.
It really emphasizes that for foreign applications, that early public accessibility in the home country is a big deal.
That's a really important distinction. Public availability in the foreign system triggers it, regardless of the final patent. Got it. Okay, next term. Laid open foreign applications. What does laid open mean?
Yeah, so in many countries, unlike the older U.S. system, patent applications are automatically published or laid open for public inspection after a certain period, often 18 months, before they're even examined or granted.
So it's not a patent yet, but the application itself is made public.
Precisely. It's a pre-grant publication step.
How does U.S. law view these late open documents? As prior art?
Yes, they can be considered printed publications under U.S. law, which makes them potential prior art,
Yeah.
even if they aren't, printed in the traditional sense, cover to cover.
The printed publication, even if not fully printed, how does that work?
The key case is in Rewire. It involved an Australian application that was laid open. It wasn't fully printed out like a book, but the information was available, accessible to the public through the Australian Patent Office system.
And the court decided.
The court found it was sufficiently accessible to the public to qualify as a printed publication and therefore prior art under U.S. law. Again, it comes back to accessibility, not the physical format.
Accessibility, accessibility, accessibility. Seeing a theme here.
Definitely. It's the recurring theme in this whole section.
Okay, last category. Unpublished, pending U.S. applications. These are still active, but not public yet. Surely they can't be prior art.
Generally, you're right. They're confidential. Unless they get published later or reissued or maybe involved in a proceeding where they're opened up.
But I sense another but.
But the MPEP does allow for provisional rejections based on unpublished pending applications in very specific limited situations.
Whoa, okay. Rejecting based on something secret. How? When?
It typically happens under 102A2, pre-AIA 102E, or sometimes even 103 for obviousness. The usual trigger is when the unpublished application and the application being examined share common inventors, or they're owned by the same company, the same assignee.
Ah, so there's a connection between them.
Right. And critically, the claims in the two applications aren't patentably distinct. The examiner's thinking is, look, this unpublished application might become prior art if it publishes or issues, and since it claims basically the same thing and has common roots, I'm flagging it now.
So it's like a heads up, a potential future problem.
Exactly. It's a provisional rejection. It might go away if the other application never publishes or if the claims are sufficiently differentiated. It's complex, and the MPEP points to other sections like Section 804, 2136, and 2154 for the nitty-gritty details on these types of rejections.
Okay, that clarifies the provisional part. It's conditional. Wow, this Section 2127 really unpacks a lot about what counts as prior art from application documents. It's definitely not simple.
No, it's quite nuanced. You really have to look at the type of application, U.S., foreign, abandoned, pending, laid open, and how and when its contents became publicly accessible, and under which specific part of the law you're analyzing it.
Public disclosure, accessibility, timing. Those are the big takeaways.
Absolutely. Critical stuff for anyone writing opinions, prosecuting applications, or involved in patent challenges.
Well, this has been incredibly helpful. And on that note, we need to give a big thank you to Mike Shepard. He's the creative director who envisioned and organized this entire educational series.
You're here. His efforts are making a real difference in making this material more understandable.
Truly valuable.
Mm-hmm.
And of course, our standard but very important disclaimer. This overview was put together with the help of AI tools like ChatGPT and NotebookLM. It might have errors or leave things out.
It's definitely for educational and informational purposes only.
Absolutely. It is not legal advice. Don't rely on it as a substitute for the real deal. Always, always consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Couldn't stress that enough. Official sources are paramount for any real decisions.
Okay, so before we wrap up, here's something to chew on. We've talked a lot about public accessibility. With information becoming increasingly digital, global, instantly searchable, how do you think that continuing trend might reshape what publicly accessible even means in patent law down the road?
That's a great question. The lines could definitely get blurrier.
Something to think about. Until our next deep dive.